What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great night so far. Sunday night. Hope you guys had a great weekend. Excuse me. Hope you guys had a great weekend. It's been a crazy weekend for me. We got some I got some court. I got some court. Let's watch some court. We're gonna start with Judge Simmons. Yeah, Judge Simmons. It's a little pro se case that's kind of funny. The main case I want to play, though, is at the end, which is also Judge Simmons. It's a follow-up to a case I played about a month and a half ago, I think. I put the description to the part 1 in the description, but it didn't end. There was an hour-long hearing on a contractor unhappy with the work done to his house, tried to sue the contractor, and they got countersued, and it's a mess now. But that's at the end of the video. We're going to go through a couple of small clips before we get there. I've also got an update on Miss Haley and Andrea, but I'm not going to say that now. I'm gonna save that until before the Judge Simmons case. I want a few people to roll in because there's a major update in Miss Haley's case, and yeah, I'm gonna talk about that here in about 15-20 minutes after the first couple clips get through. But thank you all for joining me. Let's get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. Let's go.
Representing Theodore Gomez.
My understanding is that he's still going to represent himself. I'm not sure if he's ever submitted a discovery request to our office or if he's gotten discovery, but that was what they adjourned for last.
Mr. Gomez, can you start your video, please?
You know what, J Hart? If you weren't my friend, I would be very upset with that. Why would you jump in here and say, who did today? Man, Bengals start 1-4 with 16-point differential in all 4 of their losses. But we're not here to talk about football. We're not here. All right, let's go.
I got it.
Heather!
Here we go.
Mr. Gomez, are you representing yourself?
Yeah, I'm
Still,
pro.
or
Yeah, pro se.
Morning.
Yeah, good morning, Your Honor.
did you get your discovery? Good morning.
No, I haven't gotten it. Was I supposed to request that?
I told you that last time.
No, you didn't tell me
You're
that.
I did tell you that on the record. If you're going to represent yourself, you need to request it. Not only did I tell you, the prosecutor told you.
I didn't remember that. I'm sorry.
Why is it that you believe that you are qualified to represent yourself if you don't even know that you got to get discovery?
Well, I guess I don't have a good answer for that.
Yeah, operating this way can land you in jail for 93 days. You know that? So
I understand, Your
you
Honor.
could end up with a conviction because you didn't get adequate assistance of counsel.
My apologies.
Well, it's not about apologizing. It's about protecting your rights. And I don't think you're in a position to protect your rights.
I understand.
Is there a particular reason why you wanted to represent yourself?
Well, I thought I could handle it. I am a former candidate for the bar. I went to a law school.
You graduated from which law school, sir?
Well, I didn't graduate. Rutgers University School of Law, class of
Oh,
'83.
You did not graduate from law school?
No,
Okay, so you're not a lawyer.
no, not.
And you don't know that you need to get some discovery. You need to even see what it is that they're using against you. You don't even know what it is.
Well, I don't know. I don't know how I missed that. Because
Okay. Okay. Are you employed, sir?
I'm retired. I'm a master electrician.
Okay. Okay. And so you still take the position that you want to represent yourself, or did you want to request appointed counsel today or time to hire an attorney?
Well, I guess
It's your option. You can waive counsel if you want, but I don't think it's a good idea.
okay. I can request appointed counsel.
Okay, I'll have an attorney log in to do an intake with you.
All right, thank you.
You're welcome.
Biggin, thank you so much for the raid, my friend. Thank you so much. I appreciate it, Biggin. Welcome to all the Biggin Raiders. I was over there watching. I wasn't very active in the chat. I've been doing a giant balancing act today, and I will explain everything here shortly. I just want to get the first couple of clips finished with, and then I'll give you an update on Haley and Andrea. But yeah, this is just a quick one. This guy tried to go pro se, didn't know he was supposed to request discovery. Giant fail. Giant fail.
Your Honor, would you like me to speak to Mr. Gomez?
Yes, but you're representing the Jackson? Yes, I'll do it. On the record in the matter of the people.
All right, yeah, I knew that first one's a quick one. I've got one or two more quick ones before we get into the main case I want to play tonight. And after the next couple quick ones, I will give the update on Haley. I just want to give people a chance to roll in since I've only been live for 7 minutes. But Biggin, thank you so much for the raid. That is awesome, my friend, and welcome to the Biggin Raiders. Thank you so much. All right, next one.
Come up, Tamara and Brendan.
It actually could be one of, I don't know. Either one.
All right, Miss.
Janeo. Sorry if I mispronounced your name. My internet connection is not always great, which is why I don't go on video. But it could be either one. If my internet connection goes down, it'll start to go blurry. Or, maybe just if it's possible, just change the setting on your YouTube to up the video quality. I know that's an option. I know mine resets sometimes when I'm watching court all day, and it'll just jump from 720, which I think is the highest, and it'll just jump down to like 360 out of nowhere, and I don't know why. But that's an option.
Tamara, go ahead and get it started. Give me a brief overview of why you're here and what you're asking for. You can give him a copy so he can follow along. She's going to give you a copy of what's going on, so you know where we're at.
I hired a defendant to fix a bathroom renovation from a previous contractor who did it incorrectly, the flooring.
So you're now at 2.
Yeah.
Okay. Well, I don't know the story, but you're here, so obviously it didn't go as planned.
Yeah.
Okay, go ahead.
So he initially quoted me $3,311.62 with a deposit of $1,722.04, which I paid. Once he did the demo, he said there's additional work that needs to be done. So then he quoted me a new scope of work of $3,598, which required a $2,000 deposit, which I paid.
Okay.
And then after that, there were delays and excuses of reasons why he couldn't show up and do the work. And when he would show up and do the work, he would only stay like 10, 15 minutes and then leave. And then that started in November of 2023. And then there was back and forth conversation through text messages of why he didn't show up, and then he just stopped answering my phone calls and stopped showing up, and that was in February.
Okay.
So he did not complete the work.
Okay, so let me get this right. Your first contract said 33,1162 with the 172204 deposit. You paid the 172204 deposit, but then that 3311 was out the window. It went up to 3598.
Correct.
Okay, and then you required another 2,000, so you paid almost 372204. 33,722. I'm sorry.
All right, a quick little background of this case. This is Judge Garcia out of San Antonio, Texas, and this is an interesting case because I'm going to say this kid. I don't know how old he is, but he looks like a kid, right? He really does, and he owns his own contracting business, not fulfilling his contracts. Let's just say this isn't the first person taking him to court. And the reason why I'm playing this is, one, because of his age. If I hired not a general contractor, but if I hired a plumber and then a kid showed up, and he claimed to be the owner of the business, I would immediately be skeptical. Not saying that a kid can't do the plumbing work. It's just when you see that bright-eyed face walk through your front door, like, I don't know if I called the right person. That'd be my first thing. And then when all the issues come up, yeah, it might end up like this. But this is a potential scammer, which is why this clip's here. I was going to make this a video of its own, but this is now 2 weeks old and it's Sunday night. I just kind of wanted to get rid of it. I've been really busy over the last couple of days, so I didn't have time to make it a video of its own. But this is a potential scammer, and you're about to find out why.
$3,722.04 just on deposits.
Correct.
Okay, and that's all that was paid right now. To him.
Yeah.
Okay. All right, and then let me see here. And then this started in November. When was it tentatively supposed to have been finished?
December of 2020.
Okay, so it was only a 30-day project supposedly.
Correct.
Okay, so right now,
Is that true? Like, is he actually a scammer? I would think that if he actually was a scammer, he wouldn't show up to court. That was my thought. But he's there. He's trying to take care of it. So I'm thinking maybe he's not intentionally a scammer. But once you hear the story, it definitely sounds like a scam. And Judge gives him a giant speech at the end of this. All right, I'm gonna let this play out. This is about 10 minutes long. It's not a super short one, but it's not a long one. But I'm gonna let it play out.
what are you asking for?
I'm asking for a total of $13,009.87, which includes the deposit that I paid to him, the payment that I made to the new contractor to fix the work, the replacement material, $348.34, the court cost of $140, and then the inconvenience paid from November to April of being without a bathroom, the $5,999.49.
And where did you calculate that 5,000 or what?
I just calculated that it was about $30 a day.
Okay. Okay, so let's take out that and take out the court costs and give me your two deposits that you paid for and the money you had to pay the other person to fix it. Give me that total.
The money that I paid him was $3,722.04.
Okay,
What I paid the contractor, this is on page 1, by the way.
okay.
What I paid the contractor was $3,700. And the replacement materials was.
I know I said I was going to let this play through. Aaron Reese. Aaron, I really hope you didn't bounce out on Friday when I was trying to defend you. When you came in halfway through the clip, I tried to defend you, told everyone, like, you came in halfway through. You're not a bad guy. You didn't understand what was going on because you just entered the case. So hopefully you heard that. I didn't see a comment after from you. But just letting you know, since you were here now, that that everyone forgave you for your comment. You didn't understand this situation, and yeah, everything's good. So hopefully you heard that.
Gotcha.
$48,034.
Okay. All right, give me 1 minute, Ms. Tamara. Now, go ahead, Mr. Brendan, talk to me, what's going on?
Okay, so, we did start the project in November, and it did take a lot longer than we should have. And then I had some delays due to some family matters. But as far as any other damages or anything, where we had left off, we had fixed the subfloor, which is the frame that was under from the previous contractor that had, water damage. And then the plumbing that was done incorrectly by the first contractor, and we had finished that. And it got to the point where we were starting to do the shower floor and the tile that was around it. We had asked for a draw, and I'd never heard anything about it. And then we continued a little bit farther, and then, I ended up, why the contact ended up stopping was, my phone was with my grandmother, and she had passed away, so I didn't have that same number anymore, and I had no longer had that phone, so I didn't get to contact her anymore. But where we did leave off was the tile and everything, and it was left unfinished.
Okay, so you're not disagreeing that you owe her something?
Yeah, no, I'm not disagreeing.
Okay, and so what do you think you owe her?
I mean, where we had left off.
Cause
it
she's
was-
at, what, almost 3722 is what she paid you only.
Yes, ma'am.
So out of that 3722, what do you think she owes you? Or what do you think you owe her?
We completed the floor on the outside of it. We did do some additional work behind her vanity. That was some sheetrock. And then in there, we were about 85% of the way done. I mean, at least half of the 3,300 is what I think would be fair.
And so about 1,800. Okay. Talk to me, Ms. Tamara, about the pictures. What am I looking at? Let's start with number 5.
Page 5 or tab 5?
Tab 5.
Okay, 14 is what it looked like before he did the demo.
Okay, so this is what you needed him to fix,
Right.
whatever was on here, okay?
Right, page
Okay.
15 is what the flooring, the grout on the flooring, came up, and it was, the water was building underneath it. It was like when you would step on it, the water was coming up.
And this is after he fixed it.
No, this is the previous
Okay.
contractor.
Okay,
So that's why
okay.
I needed it to be corrected.
Gotcha, okay.
Okay, and then page 16 is the demo that he completed once he took up the flooring and so forth.
Okay.
17 is the plumbing that he had done, which the new contractor, I don't have pictures
I'm from Cincinnati. It's like northern Kentucky. I'm close.
of it, but the new contractor had to redo the plumbing. He said the plumbing wasn't done correctly on this, and it wasn't aligned with the faucet on the wall. It wasn't aligned,
Okay.
and the plumbing wasn't installed correctly.
Okay.
Page 18 is how he left it. That 18A is the cement that he put on the flooring right before he put the tile. And I texted him and told him that I wasn't happy with it because it was not leveled and you could see where it was higher than others. It wasn't installed correctly. So that's how he left it. And page 19 is.
Okay, hold on. Go back to this. So A is how he
Yes, Sparkle. I'm gonna give the update on Haley and Andrea after this clip. So I was letting people come in. I don't want to. It's gonna probably take me about 5 minutes to explain what's going on. So I'm gonna wait till I was waiting till the middle of the video to do it. So we're gonna wait till after this clip, and I'll give the update. But thank you for the super chat.
supposedly evened it out, and then B and D is what he put on top of that.
Correct.
Okay.
And then B is the text message where I sent to them telling him I wasn't happy with the way that the shower floor looked. And he said he would fix it.
But she didn't.
He didn't. He never came back after that. And then 19 is the pictures of the wall, the tiling on the walls that he took off, and then the way that he left the floor. And then, of course, the curb wasn't completed as well.
Okay. Mr. Brendan, is this a good depiction of how you left everything, number 18 and 19?
Yes, ma'am.
Okay, Go ahead, what was number 20?
20 is the baseboards weren't put back on, and then 20A, you can see where he cut the door frame to put the tile in, and then the baseboards were not put back on the flooring. That's what that's a picture of. And then 21 is just, asking if he was gonna come and finish it. The bathroom, he was asking for additional money, more than what I had already gave him for the deposit. And I told him I wasn't gonna pay him any more additional money because he wasn't showing up to do the work and he wasn't completing the work. So then 22, I started looking into it and I looked up his business and he had Google reviews. He removed it from online and I noticed that there was reviews from other customers that said that he's a scammer and that he's done the same thing to them where he doesn't finish the work. And I showed him the screenshots of the things and he said that doesn't have anything to do with him. But you can clearly see that his business, at least on here, that they were saying basically the same thing that happened to me. I also posted it on Nextdoor and a lady reached out to me and said the same thing happened to her, but she was able to get her money back. And I contacted her and she told me that it happened to other people as well, that he's done
Does
this.
she have to take him to court?
They were trying to go to the news and get him exposed on the news and so forth. So I don't know what she did pursuing that with the other ladies that she was telling me about, but he's done this many a times before.
Mr. Brendan, what's going on?
As far as the bathroom, I'll address that first. With the incorrectness, where it was stated that the contractor had said the plumbing we had done was incorrect. Everything was up to code. These pictures, you can see that so it was true that it wasn't aligned with the shower, where it comes up to the plumbing for the shower head. Now, the plumbing inside the wall that that was already done by the previous contractor that it needed to be fixed. That was left untouched. Now, the one on the floor, we aligned it as much as we could, but if you look at 17B, you can see to the left that there is a floor joist going there, so it really couldn't move to all that much. But as far as everything else, it had the V-trap and the right grade of everything for even flowing.
Mr. Brendan, what's going on with your reviews and
So,
your
as
lack
far
of
as that-
reputation?
So, yes, ma'am. I had a lady that I had done work for of December of 2022. And she didn't like the work and there was some stuff that I stated that she needed and she didn't want to pay for it. She told us to do it the way she did or the way we were supposed to do it. And at that time, it was just, I was a little bit newer to doing business. I should have done a little bit more research and just not have done the work, and give her money back for that. But it came out to where the floor was on level. And that lady, me and her have another dispute going on, but she has had her and family members harass myself, in my business at the time. So all those reviews were from her family members. It was one lady that kind of had everything going.
All right, and then what number does it show your new contract and what you paid for it? Is there a tab on there?
Yes, it is.
I think I'm looking at it, but is it number 5?
Tab 3 on page, for the new contract, on page 7.
7, okay.
It starts with page 7.
And you said tab 3?
Yes.
Right. Okay.
Seven to 9 is the contract and 10 shows where I actually paid it.
All right, anybody else have anything else to say? All right, so Mr. Brennan, and Ms. Tamara, after hearing all the testimony, seeing all the evidence, seeing all the pictures, seeing all the contracts, by your own testimony, you didn't complete the job, okay? I have pictures, I have, reports from the new, company stating, and by your own admission, it wasn't lined up, the plumbing, not by anything you did, just it wasn't lined up. And Mr. Brandon, what you need to realize that when you take the job, you take responsibility. So we get y'all to go out and do it because we're not the experts. Just like I wouldn't call you to come sit down and do a case because that's not your area of expertise. I expect that when you offer your services that you should know what you're doing, otherwise we wouldn't call y'all experts. Okay. So by your own admission, it was crooked, the plumbing, but again, nothing that you particularly did, but it was crooked. You didn't complete the project. So therefore she had to go and hire somebody else, which I have receipts, everything that she has paid for, contracts. So at this point right now, what I'm going to go ahead and do is the total amount of the work was $37.22 that she supposedly paid you. Yeah, you did some work. I'll take 1,000 off. You did do something. Then she added the 3,700 to correct everything that you did. Then the material. The pain and suffering, it's a little hard to calculate. Unfortunately, Ms. Tamara, we don't really do pain and suffering in this court. You can take them to another court if you feel that that's something you need. But at this point, I cannot give you the 5,000 for the pain and suffering. I can give you your court costs though. So judgment's going to be in the amount of $6,770.38 plus your court costs, right? And then at that time, Mr. Brendan, just a little word of advice. The number one cases that come into this court are auto repairs and contract work. Those are the number one cases. And unfortunately, the construction company has gotten a bad rap. Okay. And I'm not saying you're one of the reasons why, but if you are someone that goes out there and tries to scam people, it is going to catch up to you. And the DA is looking into all of these cases, and they do come to these courts and review all these cases. So I'm not here scaring you, and I'm not here going to threaten you. I'm not going to do any of that. I'm just telling you that hopefully you are not one of these people that are scamming other people, because believe it or not, sir, we work hard for our money every day. Okay. And we expect the contractors to work just as hard. And you're young, you can go out, you can get a job. So start working for your money. If you are somebody here trying to scam things, it will catch up to you. It will. And unfortunately, there is no say in all of that because everybody's got proof of everything. Okay. So if there's projects that you think you are unexperienced in, please don't take them, because you will end up in this court and you will lose every time. Because once you put your hands on it and you accept that responsibility, you can't come back and say, well, I couldn't fix it. Sorry, but I still took your money. It doesn't work like that. Everybody works hard, very hard for their money, and they don't want to just throw it away. And then we don't want to lose faith in all these construction people, okay? Because I know y'all work hard for what y'all do, and it's manual labor. I get it. So please don't be one of these people that are the scammers, because I would really hate for that to happen, because the DAs, they're not playing around with that anymore. And they are taking into consideration all the cases that come through the JP courts that have to deal with construction and mechanics, because those are our number one cases that continuously get filed for these reasons. So please reconsider the projects that you do if you cannot do them. Okay? That's all I'm going to tell you. All right. Thank you, ma'am. Here you go. And thank you, guys. Y'all are free to go. Judgments will be mailed.
All right. So yeah, that was a scammer case. Like I said, I was gonna make that a video on its own, just to ask you guys how you felt. Do you think he's a scammer, or do you think he's just a kid making dumb decisions? Apparently, a couple of the people in the comment section or in the chats already said he's been reported as a scammer. I'm not gonna say he's a scammer. I'm just gonna say he's a kid doing dumb things. That's what I'm gonna say. He's taking jobs that he thinks he can just look a video up on YouTube and figure out what he's doing. It doesn't work that way. It doesn't. And that's why I said at the very beginning of the clip that if I hired a contractor to do a serious plumbing job, I'm not just talking about, replacing my garbage disposal. I'm talking about an actual plumbing job where you might have to remove floorboards and I see this bright-faced kid walk through the door and nobody else behind him, I might start questioning that. I'm sorry. He's like, dude, you look 19. Just saying, can I see some references? Can I see something you've done before you start tearing apart my floor? Just saying. You know what? But you know what? I'm just gonna stop talking. All right. I promised you guys an update with Haley and Andrea, and there is an actual major update. It's actually very big, and there's a reason why I put it in the middle of the video, because I don't really want it getting out for people that just skim through the video. Now it's going to get out, and I know people have already seen it, but Judge Simpson called an emergency hearing tomorrow morning at 10 a.m. Judge Simpson called an emergency hearing on Haley's case, and we don't know why. We have no idea. So Haley received an email from the courthouse saying that they scheduled an emergency hearing tomorrow morning. So they're going back to court tomorrow morning, and I will be there. I'm gonna go. I'm exhausted. I was hoping to, maybe get a little sleep back by Friday, but so it's gonna happen tomorrow. So I'm gonna go. And I've talked to Andrea about this, and we don't really know why the hearing's happening. Now, there's a lot of things that it could possibly be, and all I'm doing is speculating. But it could be because, maybe the court saw the GoFundMe account, and they're just trying to close this as soon as possible. I don't know. Andrea had no information on why this hearing was called. Now, you got to remember, Haley doesn't have an attorney. Andrea is acting as Haley's guardian. So they don't have any information. So, emergency court hearing tomorrow at 10 a.m. I will be there. Like I said, I've already been in contact with Andrea, so I will meet them at the courthouse and we'll go in together. So we will see what happens. We will see what happens tomorrow. I can't see why this would be bad news, but I also don't understand why they couldn't wait till Friday. I don't understand the emergency hearing. So I've got my own opinions on why, but I'm not going to share them because it's just speculation, and I don't want that to become, this is what Colin said. So I'm going to keep my opinions to myself, but I will be back in Washtenaw in Judge Simpson's courtroom tomorrow. Yeah. That being said, if anyone wants to chip in for gas money, feel free to PayPal me. I know you guys have done way more than enough sending money to Haley. So, don't feel pressured in that. But if anyone feels inclined to send me gas money, I would appreciate it. It is not a close drive. It is a long drive. I have to wake up at 3 a.m. to make that happen. So that's why I kind of sound defeated, because I was not planning on going back until Friday, but I want to be there, so I'm going to be there. All right. How far is it for me? It's almost a 3.5 hour drive. Depending on what time I leave. Generally, I leave at about 4 a.m. to drive to Detroit. The weird thing is, Detroit and Washtenaw is almost the exact same distance. It's almost like a triangle type of thing. So it's kind of weird, but it ends up being the same time. So when I type in the 36th District Court, when I leave my apartment in the morning, it'll say 3 hours and 14 minutes. And then I'll, do my little round trip to all the courthouses up there. And then when I type in my home address from Washtenaw, it'll be like 3 hours and 10 minutes. It's like, how did I drive 45 minutes west and it's still the exact same amount of time driving south? You know what? I'm not questioning it, but I am not doing a court crawl tomorrow. I'm just going to drive up to Washtenaw. I'm going to hang out with Judge Simpson in the morning, and of course Haley and Andrea. Now, if this gets over super early, maybe I'll go check out Judge Washington. I've never been to Judge Washington's courtroom, and I really want to do so. And it's not that far away from Judge Simpson's courtroom. So I might do that tomorrow afternoon, since I'm already going to be up there. But I don't want to make it a whole day thing. Like I said, I am exhausted. It's been I've had this roller coaster since Friday, and yeah, that's why I said I don't really want to spend 6 hours on the road tomorrow, but I want to be there for Haley and Andrea. Okay, all right, I'm gonna stop talking. That's the update. Emergency hearing tomorrow. We're praying that it's good news hearing, and my gut tells me it's a good news hearing. My brain has me going in 10,000 different directions for any possible reason it could go wrong, but I don't believe that that's the case. I think it's a good news hearing. I really do. Okay, that's the update on Haley and Andrea. Also, the last I checked, the GoFundMe was right under $25,000. So you guys have been killing it. But I haven't checked since before the Bengals game. And right before the Bengals game, so about 12 my time, noon my time, it was at 24,700 and something. So yeah, you guys are absolutely killing it. You guys are absolutely killing it. Okay. All right. Now, I believe this is the case that I wanted to play. This is the Judge Simmons case, the follow-up case where, hold on, I'm going to play the first couple seconds. I just want to make sure it's this case. So I may have put another small one in. Yep. Okay, yeah. Just making sure. I didn't want to prep this case and then it'd be another like 6-minute clip and be nothing. But this case is, I kind of said it at the beginning of the video for the people that weren't here. Part 1 is in the description. If you haven't seen part 1, check out part 1 where you actually see the hearing where this homeowner / contractor goes pro se against an attorney, and he gets his butt handed to him just because he doesn't understand the rules of court. From what I saw, he had solid arguments. He just didn't understand how to present them, and he got denied because the attorney, this attorney that's actually on the screen right now, he's not going to allow him to, put evidence into the record inappropriately. So he will shut him down every single time. And I really strongly believe this guy lost because of that. And you're going to hear a couple of facts, especially at the very end of this video, where I think that is true, because they offered him a settlement. And we didn't hear this in part 1, but they offered him a settlement not to take this to court. So they offered him money. But then he got demolished in court, and now he owes them a bunch of money. So this is what this hearing's about. So, all right. You guys are throwing up super chats like crazy. Let me knock through these super chats before we start. First off, Legal Fiction. I don't want to forget about you. Thank you so much for the 5 gifted memberships, Legal Fiction. You are awesome. Thank you so much. Welcome to the 5 new members. Sparkle Boots already called you out. Sparkle Boots, you are awesome. You deserve a second call out. Derval Martin's super sticker. Thank you so much for the $10 Canadian. I appreciate it. I love Canadian money as much as I love the double. Thank you so much. Is it Derval? Derval. I feel like that's not how you say that. I feel like one of those letters might be silent. But anyways, thank you so much. Mayor, here's half a gallon worth. Thank you so much, Mayor. I appreciate it. Good to see you, bud. Good to see you. $50 super sticker. James Scott, thank you so much, man. James, that is awesome. That's super generous of you. Thank you so much. I appreciate it. Then Robin with the $20 super sticker. You guys in the super stickers. Thank you guys so much. Robin, James, you guys are awesome. Thank you so much. Thank you so much. All right. Let's get on with the case. I've been rambling for about 10 minutes now, I feel. So I know you guys want to watch this, so let's go.
Pryor versus Simon Zaney. The case number actually is 23-02133. Counsel, can I have your appearance?
Good morning, Your Honor. Edward Zane on behalf of defendant Simon Zaney.
Let's take your name for the record.
Anthony Pryor.
Okay, today's the date and time.
Oh, Heather, I got to say this on the record. You know what I picked up in Starfield the other day? There's actually a double in Starfield as a consumable. There's something called, it's the Canadian, I don't remember what it's, it has the maple leaf on it. You've seen it, the Canadian brand in Starfield, but it's called double. And it says underneath it 2 creams, 2 sugars. And I absolutely found it hilarious. I am never going to sell that item. I'm going to carry it on me at all times because I'm going to think of you every time I see it. I just had to let you know that because I don't think I've told you that since I found it. Okay, let's keep going.
And set for a motion for attorney's fees, which the court has. However, there was not a judge's copy filed. So it was just stuck in the file. And then I do have a copy of your written response. Did you give a copy or service or a copy on Mr. Zaney? Mr. Zaney, did you get a copy of his response?
Your Honor, we got a copy of this response. It was improperly served on my secretary, but she gracefully had forwarded to my attention. And Mr. Pryor, I'm not sure why he would send it to her, but that's how it went. And I did receive it, did review the scribbles, and I'm prepared to proceed.
Okay, you can make your motion on the record.
Thank you, Your Honor. Today, as the court indicated, is our motion for attorney's fees pursuant to an offer of judgment in particular. As the court's aware, the procedural history, I'm sure we've outlined it in our motion pretty exactly, but inevitably we get to trial, we get an order of no cause against Mr. Pryor. Leading up to trial, well in advance for 28 days of trial. On June 3rd in particular, my office provided by personal service offer of judgment to Mr. Pryor. Mr. Pryor rejected that offer of judgment verbally, but I think by failing to respond in writing. During the course of that, we go to trial. As indicated, we get a no cause. So therefore, the average offer is exceeded. Hasn't been exceeded. We ended up in a better position and ultimately present this motion pursuant to MCR 2.405. I've outlined the timeline because this court rule has various, I think, specific aspects of it. We filed this motion within the appropriate.
Yeah, and now you hear my amazing editing skills. You hear Judge O'Donnell in the background. I'm going to fast forward it a little bit. Hopefully I correct it.
The Exhibit D articulate.
I did not yet, at least. He's so soft. He needs to speak louder. Judge O'Donnell, speak louder so I know you're here.
Third.
You did what you did. You
To the
told
date
her.
Oh my gosh. Please tell me that I didn't waste his entire clip.
With my roof,
You're better off going there.
He's still going. He's still going. All right, I'll recap. I'll recap everything that's going on. The beginning part of this is actually kind of boring. Hold on. Let me find where I actually fix this, and then
Multiple reasons. Please.
That in the
I'll just put in
contract.
referred to.
Well, I'm just saying with an account.
That's a court.
oh my gosh, I let this go for a long time.
In rights, I mean, he's like literally like.
Okay. All right. So for everyone that doesn't know what's going on, this guy in the red hoodie in court, he filed a lawsuit. He was suing a contractor that was supposed to do work on his roof. He was not happy with the work on his roof and ended up spending a lot of money. And then he hired another guy to come fix it. And then he tried to sue the original contractor. Now, he went to court. He had a bunch of pictures, a bunch of evidence that he didn't know how to put into the record. The attorney kept objecting to it. You can't put that in. You're not putting it in properly. Whatever the official objection is. And this guy lost. Even with all this proof or all this evidence that his roof was messed up and what they didn't follow code or they didn't do whatever. Now, remember, like I said, this guy in the red hoodie, he is a contractor. He does, I feel like he might be a mechanic, but he's one of those guys that does a little bit of everything. So that's how he knew his roof was messed up. And so he decided to sue the guy that worked on his roof. Now, he took him to court and he lost, even though he knew his roof was messed up, mainly because he didn't know how to introduce his expert witness to say that his roof was messed up. And it was objected to, and he lost the objection. So he wasn't allowed to introduce his expert testimony that said his roof was messed up. So he lost the lawsuit. And this entire hearing right now is because the attorney decided to charge him like an astronomical fee. Because he lost, he's charged attorney fees from the other side. And just another layer on the cupcake. This attorney is the brother of the contractor. So this guy most likely worked for free or at a very small rate. And the homeowner brings this up. It's like, it's his brother. Why am I being charged, this extreme rate when it's his brother? But so that's what's going on. Because I suck at editing, we missed a lot of conversation, but that's pretty much what's happened so far. But before I go any further, you guys, like I was hoping for like $25 for gas money. You guys just blew it out of the water. All right. There's a natural break in this video because there's two parts of it. So I'm gonna read off all the comments that you guys sent me when that happened, but I'll read off the names of all the PayPals and Venmos right now. Sparkle Poots, of course. Sparkle Poots are awesome. Stu, I'm gonna call you Stu. I know you're legal fiction, but I'm gonna call you Stu just because I feel better. I feel like we're on a first name basis now. Thank you so much. Legal fiction, that is a ridiculously generous. Brian, thank you. Kayla, thank you. Jedi, ridiculously generous. Thank you so much, Jedi. And Tammy, thank you so much. I'll read off the comments during the natural break, but you guys, I don't need it anymore. You guys can stop. Please stop. Like I said, I was hoping for like $25. Like that's literally all I was hoping for, and you guys just blew that way out of the water. Now I feel bad. Now I feel like I'm going to add this to Haley's fund. So you guys are awesome. Thank you so much. Don't send me any more money. I don't need it. If you want to donate to Haley's GoFundMe. So let's keep going with this. And like I said, I'll read off the comments in your super chats during the natural break of this. But hopefully I'm past the editing mistakes and we can keep going.
The deposition itself was an abuse towards me about my past. It had nothing to do with the roof. I spent 3 hours at this man's office being interrogated about my past, not about anything to do with a job at my house or my presence or my residence with this roof. It had zero to do with any of it whatsoever.
Okay. You had a right to bring an attorney with you to any deposition. Don't talk over me. You had the right to bring any attorney with you to the deposition. You had a right to make objections to questions that you thought were abusive or violated your rights in any way. You proceeded with the deposition. The court was not even made aware that there was a deposition until after it happened. So talk over me one more time and we don't have to have a hearing. So to come now and say that the reason why you don't believe he's entitled to attorney's fees when he is in fact an attorney, he's a sole practitioner, he does have an hourly rate. You didn't need to bring me a little.
I will give credit where credit's due. That was No and No. No and No emailed that attorney. You guys all know No and No. I know I shouted him out like crazy on Friday. I will never stop blessing No and No for his action in Friday. He was the person that started everything. If he didn't send that email to that attorney, none of this would have happened. I was in the right place at the right time, but No and No had the let's you know what, part of my swear words, but I'm gonna do it. He had the fucking balls to see an attorney on YouTube, look her up, and send her an email while she's on the record. So No and No deserves as much respect as anyone else does in this entire thing. But that is what happened. So I don't know if No and No is still here, but thank you so much, No and No.
A little bit more substance than the fact that you didn't like the settlement offer and you also didn't like the questions at the deposition, because he also highlights that in his motion that there was an offer to settle and you also have the right to counter offer and settle. And did you counter offer to try to resolve this short of a trial? I can't hear you on that. Okay. You can continue with your argument as to why you don't believe that he's entitled to attorney's fees for his work.
Let everybody take credit for this. No one person should take credit for this. This is a community-wide thing. If everyone deserves credit for this, not one person. Yeah, and this is what I was trying to say on Friday, and it's what I've been trying to stick in No and No's head because he keeps trying to tell me he doesn't deserve any credit. No, everyone in this entire community deserves credit for this. If someone tries to say that they're the reason, then that point fingers at them and tell them just to hush. But don't make them feel bad, because everyone is taking part. But it's the entire community. It really is.
I request that it be dismissed because there was, with prejudice, because there was no pre-approval from the court for this excessive amount of inflated hours and fees for his defense from the deposition time until trial time. I don't believe that 80% of his preparation was needed for any of the case. If he's got so much experience and time here in the court, he shouldn't need to prepare so well.
So that's a good argument. Did you want to respond to that?
It was necessary because we believe this case was frivolous and that Mr. Pryor was presenting information in a fraudulent way. And we had to anticipate the unknowns in this case, Your Honor. That deposition was 3 hours because of the difficult nature of answering questions and the information garnered in conjunction with the preparation. I have an obligation to my client that requires full preparation. Every bit of that, and there's probably time that wasn't recorded as it relates to trial preparation is distinctly different than anything else. As the court's well aware, trial preparation, you have to make sure you have your law. We put a memorandum together for the court as it relates to the issues relevant to this case to streamline this. In addition, we showed up well prepared with necessary witnesses, including an expert that we had ready to go, where Mr. Pryor failed to produce his witness. And he was warned about this. This was part of trial. He was warned about this by the court. He was warned about this during his deposition, and he still showed up on.
Yeah. Okay. I don't know who that is you're talking about. I haven't seen anything bad from anybody. I have seen a couple of videos. I mean, I think I've seen a total of maybe at least 10 different channels covering it. Some people have made some comments that I didn't agree with. But nothing bad. Let me just say that I haven't seen any court tuber that actually makes videos say anything bad. Some people have made some comments that I didn't agree with, but at the end of the day, everyone's helping the same cause. So I'm not going to call anybody out on anything. You know what? Let people help the way that they want to help. If they want to say that, they're the reason for it, let them do it. If what they're doing is gaining money for Haley, yeah, I don't care. And we shouldn't either. This isn't something we're going to fight on. And I really hope you guys aren't either. If you guys see someone doing something that you don't agree with, as long as it's not a negative comment towards, the entire thing, yeah, just let it go. If another channel is doing something that doesn't make sense, but they're still gaining money for Haley, let them do it. That's the goal. Right? Let them do exactly what they're doing. I mean, that's all we're trying to do.
Prepare. I had to prepare because I have an ethical duty to prepare, a professional duty to prepare. And every aspect that I presented was a required obligation of preparation. And I think, frankly, quite the opposite. There was probably more work done than's recorded.
Well, I am going to first say I issued I signed a pretrial statement. I didn't authorize expert witnesses. Said you said that none was necessary. So that's what we put in the pretrial statement. So why is it now an expert witness conference and that he was necessary for this? If you told me at the pretrial that there was not a need for one.
Actually, Your Honor, I think at the pretrial, what happened, I wasn't present at the pretrial. There was a confusion on a motion and the court went forward with the pretrial with Mr. Pryor, and I advised via email that I wasn't attending. So I respect that. I noted that. I take reference to that. But I would tell you during the course of his deposition and consistently the issues herein was the need for that expert that he had. So if he had presented an expert, I would have had to rebut that expert. In addition, I would need to be prepared by virtue of the expert, because the court knows I'm not a roofer, to consult with that individual to make sure I'm answering the right questions. And again, if I look at that, I don't think there was an exorbitant amount of time associated with the obligation, I think, to consult. And additionally, I think the requirements of case law require attorneys to consult experts in fields in which expertise is required. And therefore, I had the ethical and professional duty to consult, regardless of the scheduling order, that expert.
You were present because I distinctly remember you all being placed in a room and there was some back and forth, and I had to do it on the record.
That was the
because
first.
you all couldn't agree.
I don't disagree with the court on that one, Your Honor. You're right, because he was in person via Zoom. And then the court adjourned it for 30 days to get his pleadings in order because that was the issue then. And then there was a motion I had presented for, I think, a matter of default, which I just thought that was up that day, not recognizing the pretrial. Again, he's not billed for any at this time because that predated the June 3rd date. Anything we've presented to the courts June 3rd and forward. And so the substance, the court's accurate in that pretrial. The court's accurate. There was a second pretrial that the court issued a pretrial order and said no experts. I don't dispute any of that. But I wasn't at that one because that was the day in which I presumed it was the motion which I withdrew, and the court subsequently issued that order. Fine, I respected it and I abided by it. And what the court will note as part of my preparation material is adherence to that court order. We had to exchange exhibits in advance of trial. I exchanged witness lists. All those documents are part of the preparation to make sure I'm putting valid witnesses on that are prepared and necessary. And we exchanged that material, again, in accordance with that very same order. What did we get in response to that? What did we get in preparation for trial from the plaintiff? Nothing, which, again, requires, I think, additional preparation for the unknown on my behalf. Respectfully.
Do you have a copy of your deposition transcript?
I do. We also can order a video, Your Honor, given the nature of the kind of behavior of the plaintiff. We had a video deposition, and that I can tell you, I can pull it up. I don't have it here in front of me. I'm pulling it up on Dropbox. If the court would just give me a moment. And it was identified as one of our trial exhibits, Your Honor. I have a full copy of that.
Well, it might happen again tomorrow. I don't know. I have this sneaking suspicion that tomorrow's hearing is not going to be on YouTube. Just a quick heads up. It's an emergency hearing. It's a high-profile case now. I have this sneaking suspicion it's not going to be on YouTube. I'm going to take as much video, as many pictures that I possibly can, so I can share the entire experience with you guys. But yeah, it definitely was me, and yeah, I just have a sneaking suspicion it's not going to be on YouTube. But now you guys know it's at 10 a.m. tomorrow in Judge Simpson's court. So keep a lookout. I'll be there. I'm going to be wearing my bright blue shirt, my almost turquoise blue neon color shirts. You'll definitely see me. You'll see me. I'll be there. I'll be right next to Andrea, Haley, and Gavin. All three of them are going to be there tomorrow. So I'm going to be with them. I was polite and I asked permission to go with them. I asked permission if I could go with them to court, not just to show up and be a random bystander. So I will be sitting next to them.
Your Honor, that deposition transcript is 196 pages.
Judge Simpson doesn't play everything on YouTube. I've known this from the 2 times I've been in his courtroom. He shuts his feet off early sometimes, and there's still cases, and sometimes he comes back before he brings it back on. So I'm just saying there's a chance that it might not be on YouTube. I'm hoping it is. But there is a chance is all I'm saying.
Oh, that's yeah. You say you do have a copy of the transcript?
I do, Your Honor. I'm here right now. I have it available to search if necessary. It's on my phone.
Okay, I just, because his argument is that he found the questions to not align with the issues before the court and that they were a waste of his time. And so I'd like to have a review of that to see if his concerns are valid.
Sure. I could share with you. I don't think that would be the issue, but Your Honor, can I share a digital copy with the court PDF, and I can share with Ms. Nash?
That would be wonderful if you could do that.
Yes, Your Honor.
Yes.
Earlier, he had said he didn't know why I sent this to his secretary. That's because that's where I got some of their responses from, as I replied to it.
I get it, but you also didn't file your response to today, so you gotta file, you
got to be careful. There's a fine line between being helpful and being creepy, which is what I'm battling with. Because they don't know me, right? They met me on Friday. Now we got to remember this. They met me on Friday, and I've been a big part of their life for a weekend. I'm not going to be pushing anything, which is why I asked permission to go to court with them. If they said no, they want to do it themselves, I still would have gone. I just would have sat in the back and wouldn't have sat with them. So that there's a very fine line here. Very fine line. And I think that's coming from me being a man and Haley being essentially a girl, right? And she's 20. She's an adult, but you guys have to understand the fine line I'm trying to not cross. And I'm very aware of the line and not crossing it.
So I mean, I saw this when I walked on the bench.
I'm sorry, and I can explain that too.
I don't need you to explain it, but we've to his argument, there's been a lot of delay because you've not followed the court rules. You brought the lawsuit, you're required, and I told you from the very beginning, if you bring a lawsuit, I recognize that you are representing yourself pro se. You still have to follow the court rules. The court gave a lot of leniency as it relates to that. That doesn't take away from the time that it is expended for attorneys scheduling out and coming back and forth. Then Mr. Zaney appeared. I'm looking at the bill. I don't know if you looked at it. I don't even see before you a copy of what he filed. But for example, I know there were motions and I signed an order for the pretrial statement, the pretrial order in April, and there were motions in March and prior to that signing of the pretrial statement. And he's not billed for any of that. I also know that Mr. Zaney's fee is consistent with the state bar standards, and that he does, the bill he's posting here is what he would charge the general public. I just don't know that that's what he would charge to his brother. That's a whole separate issue, but that is his going rate. Do I believe that I think you make a valid argument, Mr. Pryor, about the.
Yes, and we're never going to get through this case because we're just talking about Andrea and Haley. I want to do something for Andrea. Right now, the focus is on Haley. What I'm desperately hoping is tomorrow this case is going to be dismissed and I can spend a week, gathering money for Andrea because they're not in a good position. They aren't. Andrea has gone really far out of her way to help Haley. And, it's not like she's, reining in money. So, yeah, I want to do something for Andrea. I don't know what I'm going to do yet, but after the case is dismissed, hopefully at that point, the GoFundMe will be closed. They'll collect the money, do everything they need to do for Haley. And then, something as a community, we can all get together and do something for Andrea. That's my hope. But I don't know what that is yet. That's just something that I've been thinking about for the last, 24 hours. So, okay.
The amount of time it should have taken him to prepare for this matter. He's trying to bill here for 34 hours of preparation.
If I may, Your Honor.
You may.
I don't think capsulizing is just preparation. It's diligence in the case because it starts from June 3rd and it transitions into true trial prep. And this isn't an issue of just true trial prep. It's from the dates in which we made that offer. So it encompasses, I think, a lot more. Yes, the focus was on preparation. And then just lastly, if I could just clarify a point that Mr. Pryor made that I never got to. He indicated there was a matter of the way the offer was presented. This offer was presented consistent with court rule in writing.
sir, please. You, every
Who's the
time you
same?
open your pie hole, you get it worse trouble. So stay the course, will you?
There was no way, no ambiguity here. It was offer of entry of judgment in favor of the plaintiff in a specific amount, in his favor. So to try and present to the court something contrary, I think is disingenuous at best, which has been consistently the challenge with Mr. Pryor's representation. So I
Is
did.
that offer made in writing to you?
It was.
What made you think that there was some trickery going on?
The amount was in quotations, and I know
What
that
does
when
that
you
mean?
put a dollar amount in quotations, like if I look into my bank statement, if it's in quotations, it's in a negative.
That's
That means
not,
it's below.
sir, that's
means
not
I
what
would
that
owe
means.
him.
That's
would-
that, you're wrong. That's not what
I
that
might be
means.
wrong, but that's what I thought.
Did
And
he-
when I asked him,
Do you have a copy?
I
of what he
do
wrote?
in the file. Yes, I didn't bring the whole file with me.
Okay.
I didn't.
Because why? We went through this before. Why would you not bring your file to court?
I just. There's a lot of stuff.
When you're writing, especially legal writing, and I don't know what he wrote, but I could imagine that he probably, if it was 600, typed out 600 in words, and then he has to put the 600 in quotations, because that's how you write. It's not trickery, sir.
I misunderstood his offer.
You misunderstand a lot of things, and it's reasonable because you're trying to navigate a process that you're not familiar with. But I advise you early on, you might want to get some assistance of counsel if you want to move forward with this. You might want to counsel with an attorney so that you know that you're following the rules properly, because navigating the civil litigation is not easy. And so I'm going to review this bill. Oh, you sent me. I'm
Can I
also
make
going
a
to.
statement to my defense on that.
You may.
I didn't hire an attorney because I got hit by a car in February and I haven't worked until just like 3 weeks ago, starting back working. So yeah, I couldn't afford to hire an attorney for this matter. And then if you notice, in my other case, I
don't want to hear anything about your other case.
Right. I have representation for.
I don't want to. Yeah,
I'm just saying.
Your other case has nothing to do with this
I
file.
would love to have had an attorney here. I would love to have had an attorney in this case because I believe the matter would have been completely opposite if I did. But I couldn't afford one at the time.
Your Honor, if I could just reply to the other portion of his statement.
You may.
I'd ask the court when reviewing the transcript to pay particular attention to page 100. On page 100, Mr. Pryor referenced and recognizes as part of our discussion that he was offered a settlement agreement. It was clarified for the amount approximately, and he just ignored that. And he was explaining the consequences of the offer at that time. This was something that I want the court to be aware of. And I'll rest my case on that point. Thank you.
Thank you. Any further argument you want to provide for the court, sir?
I just want to apologize. I didn't bring the file because I was busy taking my daughter to school and I didn't have time to go home and do it.
Okay. And, but you knew you had this court date before today.
Yes, I did. But I didn't have it in my truck because every time I turn a corner, I got so much stuff, it falls over everywhere. So I took it out of my truck and I didn't have it in my truck.
Okay. I'm going to set this for a date. I need time to review the transcript, and I'm going to comb through this itemization that Mr. Zaney's provided. You've not, sir, given me or gone through, I don't know if you've gone through that, or it, other than the deposition, you've not pointed to anything that I believe you had particular concerns about. So I need to just go through to see the reasonableness. I believe that he is due attorney's fees because attorneys don't work for free. That's a misconception, and it's a cross that every single attorney in the United States of America bears. As soon as they become licensed, their families and friends want free legal advice and free services, and they don't work for free. Just like I can't come to your job and ask you for free stuff. His job is legal work and his legal expertise. And if he's taking his time and he's using his resource and he's using his education, he should be paid for it. I will make a determination as to what I believe is reasonable and equitable in this particular matter after reviewing the transcript, as well as going through the 3.95 hours submitted by Mr. Zaney. I'll give you a date, the next available date for my rule. He's gonna be here on October 3rd. He's already gonna be here October 3rd. Does that date work for you, Mr. Zaney?
Does, Your Honor.
At 1:30. October 3rd at 1:30.
Thank you, Your Honor.
We'll get you a notice to appear for this as well, okay? You're all set for today on this.
Thank you. Good day.
Same to you. Anthony, James.
All right, we're gonna fast forward a week. But while we're at this pause, I want to read out these comments. This is from Sparkle Poots. Great, Colin. Just what I needed to sleep peacefully tonight, jerk. Thank you, Sparkle. I appreciate it. Thank you so much. Legal Fiction. Legal Fiction, you didn't send a message. You had a huge, generous PayPal. You didn't send a message. But thank you so much, Legal Fiction. I appreciate it. Brian also didn't send a message. Thank you so much, Brian. I do appreciate it. Kayla, coffee for the morning Detroit trip. Thank you so much, Kayla. I appreciate it. I'm definitely going to need that in the morning. I'm not going to Detroit though, unless I'm finished with court super early. I may swing by the 36th district, but I'm going to Washington, so I'll be in Ann Arbor, not Detroit. But maybe we'll see. Jedi, 2 a.m. Sith wants you to have gas. 2 a.m. Sith. For those that don't know, I called 1 a.m. Jedi, which is what her name reads at. It's actually I am Jedi, but everyone calls her 1 a.m. Jedi. I call her 2 a.m. Sith. Funny inside joke. It's funny. Thank you so much, Jedi. I appreciate it. Trip Fund, bless you. Thank you, Tammy. Thank you, Tammy, for the PayPal. Trip Fund, bless you. Thank you so much. All right. I read those off. Okay. So that the previous part was from last week. Now we fast forward. This actually happened Friday. This happened while I was in Judge Simpson's courtroom. And luckily, Judge Simmons doesn't delete her content, because when I was adding this, I was like, oh yeah, there's a second part to this. And I realized it was this past Friday. She doesn't delete it, so I was able to find it. So this gets good at the very end. And I'm gonna say this again. This guy had a case. He had a case. The attorney on the side that he was suing, so the guy who won, the attorney who won it, we just listened to for the last 20 minutes, offered a settlement. He offered, it was nothing. They're gonna say it was like $600. He offered him $600 just to go away. I'll give you $600 just to not pursue this. And the guy decided not to, took it to court, didn't have an attorney, didn't know how to bring evidence. Again, I put part 1 in the description. If you guys haven't seen part 1, you need to watch it. And this is exactly why you need to hire an attorney. The guy essentially, he wasn't asking for a ton. It was like $5,000, I think, $6,000. But he lost, and in return, he now owes the other side $11,000. And he was offered a settlement for some minimal amount just to go away. Those are important details here. And now but you understand why this guy's upset. You really do. He lost in court because he went pro se. And, he said he was in a car accident. He couldn't afford an attorney, which sucks. It really does. But it's a civil case. If you talk to an attorney about what happened with a civil case, he may have found one that, I will take a percentage of your winnings. You have a credible case. All he had to do was look for one, and I don't feel like he did. Okay, let's keep going now.
James Pryor versus Simon Zaney, file number 23-02133. Yes, please.
Good afternoon, Your Honor. Edward Zaney on behalf of Simon Zaney.
Prior.
Okay. Today was the date that we reset hearing on the defense counsel's motion for attorney's fees. The court was in review of a transcript from portions of discovery, a deposition to be clear, that took place as part of preparation for this litigation, as well as a review of the activities report for expense and the reasonableness of the attorney's fees billed. I think there was a motion for a total amount of 33.95 hours at a total of $16,412.44. The last time that we were here, there were some concerns expressed by you, Mr. Pryor, about the reasonableness or the nature of the questions that was posed at the deposition, and the reasonableness of the timeline, or how long it took for that deposition to be completed. I think it took about 2.5 hours. I reviewed the questions. I didn't particularly find any concern with the questions. I think that the time frame for a deposition typically is about 1.5 hours for this type of issue, 2 hours for this type of issue. I think it was slightly longer because I, in my observation, believe that there weren't a lot of direct responses given, but a lot of back and forth. But I didn't see anything in there that I believe to be inappropriate, the questions that were asked. I think there were a lot of questions that went into your background as it relates to other litigation. I can only surmise as to what the relevance to this would be. It could have been for credibility. It could have been for motive. It could have been for trying to ascertain whether or not, because at the time there was a counterclaim, your ability to pay. I'm not sure. But I didn't see anything that was grossly outside the nature or scope of litigation. So I think that the deposition questions were appropriate, and I think the timing was reasonable. Slightly longer, primarily because you didn't want to answer the questions. There was some back and forth in there. And so if attorneys have to keep re-answering questions or retelling you not to talk over them, that could take a little bit longer. Nonetheless, I reviewed the report. I also reviewed the court rule as it relates to attorney's fees, as well as the rules of professional responsibility as to what attorneys should be doing and cannot do when they're making a request for attorney's fees. And there are certain factors that must be considered by the court when making a ruling as to attorney fees. And I think I made it clear before that I do believe that the relationship between the attorney and the client is at stake, and the rules of professional responsibility agree with me in that regard. This is the brother of the attorney that's being represented. Mr. Zaney, you have requested or billed a rate of $400, and I believe that based on the analysis that's provided by the 2023 Economics of Law survey results, as well as your practice experience, I believe that you are a attorney that can appropriately charge that rate. However, the rules require that I consider the nature and the length of the professional relationship with the client. It is also required that I consider the nature of the case in and of itself. This was not a complex case. I don't believe, even as it was billed for the time to draft the motion for attorney's fees, I thought it was excessive. Do I think that you had to go and get new research for your motion? No, I think that you file motions for attorney's fees probably commonly. You probably could have cut and pasted the majority of your research into this motion. It's not really a long motion anyway. So I don't know that all of this time that's being spent was reasonable and necessary. I also think that the rate of $400 was not reasonable as it relates to the relationship between the two brothers in business in other facets, but in this particular case, a relationship, an attorney-client relationship. The rules of professional responsibility indicate that we know that when there is a history of relationship there, a negotiation of that attorney's regular fee is more likely to be lower than what it normally would be. So do I think that 400 was reasonable? No, and so I'm not going to grant you a rate of 400 per hour. I think that because this matter has been pending since November 2023, we had multiple court dates. There were more than one motion filed on this matter there was definitely a number of hours that were expended on this. The concern that the court does have about one of the expenses, other than the research or the time it took for research, was the expert billings, because I reviewed my order for discovery and I did not grant any expert. And so I don't understand why it would be reasonable for us to go into a rabbit hole of expert trial prep at the rate, or for, it looks like for 4 hours or almost 4 hours. There was no expert in this, at least there should not have been. This was a pretty straightforward case, and he did not present an expert. I know he presented some document about someone who came to see the roof, but I think that it could have easily have been flushed out that there was no expert noted in the order for the court for pretrial order for discovery. And we know in district court, discovery is limited in scope unless otherwise noted in the order. The order stated here, we weren't having an expert witness, and you never even, you noted some witness, but you never called them. So as it relates to any line items for experts, that won't be recoverable. So that need to be striked. I am going to also reduce the attorney fee from 400 to the median rate that was indicated in the State Bar of Michigan economic report. So that's to $3.25 an hour. So I'll let Mr. Zaney adjust his paperwork because there's a lot of line items there, and I'm not going to go through line by line to figure out exactly all the ones that were attached to any expert that needs to be addressed and removed. And then as it relates to the time it took for you to draft this motion, I found that to be a bit excessive. I think you billed almost 4 hours. I don't know that it took you 4 hours to draft this. I think you could probably draft a federal motion in less time. So on a more complex issue, if you are a attorney in that percentile with the experience that you have, this was a low level case for you. And I recognize it took time. I have said multiple times, I think you handled it, this case just like any other professional would have, but understanding that there's a very close relationship when it comes to the client attorney relationship, that's the fee will be adjusted because of that. I also want to cut that time frame that it took to draft and research for this motion. I want that cut in half as well. All the other expenses in the bill I found to be appropriate. So I'll allow you to address that, and then you can tell me what the final amount is, because I don't know if you have that in some kind of spreadsheet or something.
I do, Your Honor.
If you're able to do that right now, I can go off the record, call another case, and then we can get those final figures.
Yes, I'd like to do that, Your Honor. I'll get working on it right away.
Okay, off the record, you can have a seat, sir.
All right. Because we've already been going for an hour and 23 minutes, I'm just kind of trying to let this play. Janet, thank you so much for the PayPal. Was it PayPal? Yeah, it was PayPal. Thank you so much. Drive safely. Thanks for the updates on Haley. I will drive safely. I'm going to be crashing hard right after this. As you guys, most of you know, I'm a giant Bengals fan. The Bengals game did not go our way today. And, and then it was during the Bengals game I got the update from Andrea. So it was just a weird kind of roller coaster where it's like, I gotta go. I gotta go to Washington tomorrow. I'm doing that, watching the Bengals lose in epic fashion again. And yeah, it was a lot today. So I'm crashing really hard after the night stream. But I do want to keep you guys updated because so many of you have donated. And there's not a chance that I'm going to try to hide anything from you guys. So Yeah. So I'm going to go up there tomorrow and and I'll keep you guys updated throughout the day. So again, Judge Simpson's courtroom, 10 a.m. is the time for the hearing. Hopefully he plays it. It's probably going to. I know people were asking, why wouldn't he play it? And he plays most of everything. And I'm just saying that there are some things he doesn't play. And because this is an emergency hearing, I don't know. But that's why I'm going to be there. I'll make sure everyone knows exactly what happened. Even if it's not on YouTube, but it probably will be. All right, let's finish this one up. You guys are awesome. I think I got the super chats. I think I got everyone. If I missed anybody, please send me a message. I am right now. I've been walking away ironing my clothes for tomorrow. I'm not going to lie to you. I have my headphones in. I've been listening, but I've been doing a bunch of things since now I'm traveling tomorrow. So if I miss anybody's super chat or PayPal's, please send me a message. Since we only have about 15 minutes left of this, I'm paying attention 100%. So if I miss anybody, please let me know. All right, let's go.
The matter of Pryor versus Zaney. Mr. Zaney, what adjustments do we have here?
Your Honor, what I did when I heard the court talk about the motion prep, you wanted it cut in half, but what I did was, I also heard the court say it should have been only a couple hours. I attributed 2 hours to that work. So I took off the first 4 entries on page 1 of 4 of Exhibit D from 8:17, 8:11, 8:10, and 8:5. That removed 6 hours, and 6 and left 2. So I removed 4 hours and billed it only for 2 hours total. So I did more than the half the court had requested. I removed the $600 in costs for the expert on that same page of the exhibit from 8:1. In addition, I removed a total of hourly work for the expert to be an additional 2 hours. Any communication with the expert I removed, which would be reflective on page, the first 600 is on page 1, page 2, the entry from 7:23 and 7:22, that's 1 hour. And then the next page from 7:19 and 7:17 is another hour. I removed both of those. So it reduced, the total hours removed was 6, reducing it to a total of 27.95 hours. There's a caveat, and I'll bring this to the court's attention to make a determination. I did indicate I charged 0.75 for preparing witness fees, and where it does say there was an expert endorsement. I did not attribute that to the work of experts, but my witness list entirely. So if you would like me to remove that, please advise and I'll recalculate. Otherwise, I believe I've addressed points to in full candor to the court as it relates to witnesses. If the court were to stick with my application or my reduction, 27.95 hours at the hourly rate approved by the court of $325 for a total of attorney's fees of $9,083.75. A reduction in the expenses from $2,832.44 minus the $600 for the expert, total of $2,232.44. The grand total $316.19.
Okay. Thank you. I'm satisfied with the reductions that was made, and I will grant the request for attorney's fees in the amount stated on the record. Can you produce an order?
Yes,
For
Your Honor.
attorney's fees and costs, that is. And you can send it through my file. Do you have any questions, sir? You're shaking your head. Does that indication?
Yeah, Bill, I agree with you. I feel like I need to redo this case. I will do part 1, part 2, and part 3 because I put part 2 and part 3 in this. I did part 1 a month and a half ago, but I feel like this entire case has been eclipsed with the Haley and Andrea stuff going on. But I don't know if you guys understand. Like this is at least my opinion. This guy got screwed. He honestly did. And that's how I feel. And it's just so much else going on. I have not given this case the proper respect it needs. I should have been paying more attention to this case, but like I said, this weekend's been a blur, and he ended up paying $9,000. Well, we're about to see what the judge orders here in a second, but yeah, again, he went from getting a settlement from the attorney. He had a settlement offer and he decided not to take it and took him to court, and now he owes them a ton of money. Okay, we're gonna finish this up.
No.
Yeah, I have zero words as to what to say on how I can pay $11,000 to a defendant when my case it's not without merit. It's got, if I was to refile it, if I had an attorney, if I didn't take 6 months off from getting run over by a car, I would have been able to afford to buy an attorney. It's not that I couldn't pay his brother the $1,300 that I owed him at the end of the job. I paid for everything in advance before he even ever showed up. I have always made decent money, and I've always done really well in life. I treat people with respect. I don't rob people blind. I change tires for next to nothing. I'm every day for the public. I go above and beyond for my people, my customers. I've done so much for them, even not even just in regards to this roof or using them through business, just in life, just have helped them in multiple ways. Anytime they ever called on me on my service, I've always been there for them. So to go through this, it's affected me. It's got me in a position where I don't even know what my next move will be. Like, that's where it makes me feel. I should not owe this man nothing.
Well,
The $1,397.86 that he's trying to say that I owe him, $386 was added on after the contract was already complete. According to both of us, he should have been completing the job.
this is not a time for us to rehash
No, I
the
understand.
trial. I put it on the record, it's almost a year from the time that this case initiated. And so you were advised multiple times that you probably want to seek counsel because court rules, it's not about, you were the one who brought the lawsuit. And if you were going to bring a lawsuit, then you need to either reverse yourself with the court rules and the procedure so that you know how to move forward, or you were going to have to hire you an attorney. It's a civil matter. If most attorneys will take a civil matter on a contingency fee, meaning they see some merit and they think that they can get paid the same way he got paid after taking the case. They'll seek their attorney's fees and they'll get their money through that. Nonetheless, the court rules are the court rules, and you did not prevail. There was also an opportunity for you to resolve this matter because he proffered an amount to you to resolve and settle this case, to which you didn't accept. And that's really what set him up to be able to request attorney's fees, because there was a way to resolve it that didn't happen, and then you were then unsuccessful. If you were able to be successful with your claim, he would not be in this position to seek this amount of attorney's fees. So the court rules were clear as it relates to that. It's unfortunate. If you had evidence that you believe would properly have supported your case, you didn't present it at the time of your trial. And so that's what put you in a very, very hard situation, is because that's what the trial date was for. You were supposed to bring your evidence. There was too much. I didn't have the evidence, or I left it here, or this person had it. Any other questions for the record? Because I'm not going to be, when you talk, I checked myself to be quiet because I wanted to let you have a moment to relieve what was out, whatever was on your chest. But what I won't do when I'm talking is be cut off. This was the same thing I saw even when you were having your deposition, and I saw the attorney being patient and explaining to you, we can't both talk. So I'll let you know when I'm not talking, you're going to talk, and you wanted him to let you know when you can talk. No one's going to have to let you know when we're talking, because if we're talking, you should know you shouldn't talk over us. But when a question is posed to you, then you should be able to know when to answer it. When you were talking, I listened. Now I'm talking. You want to cut me off. I heard your case. I spent way more time than this case should have required to resolve it. I gave you more time than necessary to try to bring your stuff in here. I gave you all kinds of allowances. That costs time. That costs time for the attorney. It costs time for the court. But you still didn't bring us what we needed on the date set for trial. You didn't even have this witness that you named. So the ruling was what it was because you weren't able to sustain your burden. It's your burden to produce the evidence for the court to establish your cause, and you were unable to do that. And judgment was in favor of the defense in this matter. And as a result, there's now attorney's fees in the amount of $11,316.
Can I ask one thing?
Yes, you may.
How could it go from him thinking he's gonna settle with me, owing me money, which I misunderstood?
I can't opine. I can't opine over. So the way negotiations work, it's not really up for the court to opine as to what, it could have just been value of his time. We'll give you $600 to make this go away. It could be just a value of his time. We're gonna give you this money to make you go away so that we don't have to deal with this. There's a number of things that go into why defendants and or plaintiffs offer settlements. I was not there. I couldn't do it. I don't even know if you counter offered. It's not really germane. All I know is that there was an offer to settle and you refused to settle. I don't see anything where you even countered. And so
I'm not trying to cut you off, but I misunderstood. When I went to his office for the deposition, I was very upset. I did not want to be there. I was supposed to be at a doctor's appointment for my car accident. And he said if I didn't come, that I was going to be charged all this stuff. He was like, I got the emails. He basically threatened me that if I didn't come, that it was going to be a big problem.
Sir, you've been upset every time you've come.
Yeah, because this is
you filed the litigation. When you file litigation, it comes with stress, it comes with paperwork, it comes with understanding these rules. And so you brought it, and every time you came to court, even when you came for the pre-trial, I had to intervene. I shouldn't have had to intervene just for you to complete a joint pre-trial statement, but I had to because of your attitude. I'm not dealing with it anymore. This case is done. You're all set.
We're off the record, Your Honor, on this matter.
We're off the record. Thank you.
Thank you. Okay.
Are you threatening someone in my courtroom? Are you threatening someone? Run? Run for what?
I said we're done.
Exit out the courtroom, sir, before you find yourself in contempt.
Ooh. Yeah, I know. I put the signature line on the thumbnail and you had to wait an hour and 37 minutes to hear it. Exit my courtroom before you find yourself in contempt. All right. Yeah, this case needs more attention to it. This guy got screwed and he's mad. But it's a civil case. He tried to sue somebody, didn't have an attorney, got countersued and lost. It sucks. It really sucks for him. Because I do believe him that he had a case. If he didn't have a case, there wouldn't have been a settlement offer from the plaintiff or from the, what is it called? What is it called when you receive the lawsuit? I don't even know. The respondent, I don't know. But they offered him money just to go away. Like, okay, right, you have all this evidence. We're gonna give you this money. You go away. And so that says he has a case. It really does. But he lost, and now he owes that attorney a ton of money. Luckily, the judge cut it in half by like 25%. It went from what was it, like $12,000 to $9,000. Still a lot of money to pay. But yeah, this case deserves more attention. And I was all over the Haley and Andrea stuff, so I do apologize for everyone that wanted to watch this hearing, and I did not give it the proper attention it deserved. I will not delete this. I will save it, and maybe on a slow rainy court day, we'll revisit this just so I can properly have fun with this case with you guys. All right, that's all I got. I'm going to go crash. I'm going to go brush my teeth, go to bed. I got to wake up in 5 hours to make it to Judge Simpson's court in time. So wish me luck. Hopefully I'm not in handcuffs. I'm always worried when I go to Judge Simpson's court, especially now that he knows who I am. And now that he knows I have a channel, now that he knows that all this stuff is out there. You know, maybe the emergency hearing's about me. Can I make it about me for a second? Let's make this about me. Maybe tomorrow he knows I'm going to show up. And I'm going to show up. He's going to put me in handcuffs, make me sit in jail till Friday, till the actual hearing starts. Maybe it's a trap. It's not. It's not. But that'd be funny. That'd be funny. I'm sure you guys would, potentially help bail me out. Maybe. I can hope. All right. I'm finishing this. I'm rambling now. You can tell how tired I am. When I'm rambling, I'm tired. You guys have a great night. I will see you tomorrow. Tomorrow is Members Monday. Now, I will give a warning. Depending on how tomorrow goes, I may move Members Monday to another night of the week. I don't want to take it away from the members, but if something happens tomorrow and it's big, I'm going to have to go live tomorrow. Well, I'm going to live tomorrow night regardless, but I may not make it members only. Let's just say that. So I will, but I'm not going to take away from the members. I will try to figure out something. And this is hypothetical. Maybe nothing will happen tomorrow. Maybe nothing will happen, and tomorrow will end. Tomorrow will just be another day. Who knows? But just giving you a heads up for all the members, all the members that are awesome. Okay, still rambling. Okay, I'm finishing. I'm gonna look. Can we raid somebody? It's Sunday night. I don't know. I'm tired. I just want to go to sleep. Redirect. Add. Who's on? Nobody. Literally nobody. Nobody's online. Okay, so we're just gonna call it a night. I'm not dragging this out anymore. You guys are awesome. Everybody, thank you so much for the super chats, the gifted memberships, the membership milestones, the Venmos, the PayPals, the Cash Apps. I don't think I missed anybody. If I did, if I happened to miss you, I apologize. It wasn't on purpose. Send me a message, Discord, email me, and I will make a public apology. I don't think I missed anybody though. Have a great night. The next time you guys are going to see me is going to be tomorrow in court, 10 a.m. Judge Simpson. Let's go. All right. Until next time. Bye.